Shopify's point of sale system helps you sell at every stage of your business. Need a fast and secure way to take payments in person? We've got you covered. How about card readers you can rely on anywhere you sell?
Thanks. Have a good one.
Yep, that too. Want one place to manage all your online and in-person sales? That's kind of our thing. Wherever you sell, businesses that grow with Shopify. Sign up for your $1 a month trial at shopify.com/listen. Shopify.com/listen.
First and foremost, the framers of the Constitution gave the bulk of the war powers, including the power to declare war, to Congress, okay? Because they wanted to make going to war hard, okay? Because it was one of the most important decisions, momentous decisions the country could make. This expenditure of blood and treasure. Mm-hmm. And they did not want to leave it up to the whims of one man.
The Trump administration is soliciting bribes at home and committing war crimes abroad, and Congress is asleep at the wheel. Joining us to discuss this Article 1 crisis and what we can do about it is Brian Finucane, international law expert. We've got a lot to cover, so let's get after it. Hey guys, I'm Andrew Torres, and with me as always is Liz Dye. But today is Rosh Hashanah, so she is taking the intro off to be with family. Before the holiday, we recorded this interview with Brian Finucane, so you will hear from her in a minute. This month, the Trump administration has conducted 3 separate military strikes against what it claims, without providing evidence that the rest of us can see, were drug smuggling boats. On September 2nd, the military killed 11 people it claims were members of the Venezuelan gang Tren de Aragua. That was followed up by 2 more military strikes last week, one on Monday that killed 3 people, and another on Friday that we learned about over the weekend that also killed 3. President Trump went on social media and said that the latest attack was justified because the military attacked a ship, quote, affiliated with a designated terrorist organization conducting narco trafficking. Even if that's true, none of this is the law. These are 3 incidents in an ongoing pattern of the administration committing open war crimes. We also learned over the weekend from multiple media sources that the FBI has recordings of Tom Homan, Donald Trump's border czar, accepting a literal bag full of cash, presumably with a cartoon $sign on it, while undercover agents posing as business executives said, "We would like you, Mr. Homan, to accept this bribe in order to help us get government contracts once Donald Trump assumes office," to which Tom Homan apparently said, "Sure." Now, because our bribery laws are woefully inadequate and have been gutted by the Supreme Court ever since its 2016 decision in McDonnell v. U.S., the FBI and the Department of Justice had to wait to move on Homan because he wasn't yet in a position of power and thus had no quo to go along with that prodigious quid. And once Trump got into office and Homan was in a position of power, Trump's corrupt goons, including FBI Director Kash Patel, first stalled and then ultimately officially closed the investigation into Homan. And then Megyn Kelly said what they're all really thinking. She took to X Twitter to post, in response to the story breaking, "We do not care. Don't bother at real Tom Homan. He's a national treasure," to which lots and lots of people said, "Really, you don't care about bribery?" And when called out on it, Kelly wrote a truly unhinged rant in response to confirm that no, she does not care about corruption. It ends with, "So no, we don't care what you say about Tom Homan. We do not trust you. We only care about defeating you." So that's where we are. These 2 stories, international war crimes and domestic corruption, have a single area of overlap. And that is Congress. And yes, I know, Congress is controlled by Republicans. But I think it's worth pointing out that after Trump engineered the coup on January 6th, 2021, and tried to overthrow the country, 10 congressional Republicans voted for articles of impeachment. And then, after a damning trial in the Senate, 7 Republican senators voted to convict, and at least a dozen more suggested that the only reason they didn't vote to convict was because Trump had left office the week before. At no point in American history has Congress turned its back on open criminal defiance simply because of the political party of the perpetrators. And to be clear, This is an area where you cannot make a false equivalence between the political parties. When Democratic Senator Bob Menendez was caught with a bag full of gold bars and a new Benz for his wife Nadine, he was prosecuted by Democratic President Joe Biden's Department of Justice, as were New York City Mayor Eric Adams, Texas Congressman Henry Cuellar, both Democrats. Half of this country believes that you don't get to commit crimes just because we agree with your politics. The Democrats have. But half of this country apparently does not. And that is what our guest calls an Article I crisis. The lesson here is we are not powerless to stop this corruption of this administration. We are not powerless to stop violations of international law. We are not powerless to stop naked bribery. But it's not going to happen in the courts. It has to come from Congress. It's Article I of the Constitution. And to see how this plays out, let's take a quick ad break, and we will be back with Liz and Brian Finucane and the interview.
And with us is Brian Finucane, a senior advisor at the International Crisis Group, a conflict prevention organization which works to promote good governance and inclusive politics. He previously worked in the Office of the Legal Advisor at the Department of State, advising on legal and policy issues relating to counterterrorism, the use of military force, and partnered military operations. Brian, thank you so much for being with us today.
My pleasure.
All right, so let's get right down to it. What happened?
Well, on September 2nd, the President of the United States, in an Oval Office appearance, announced that the U.S. had blown up a vessel in the Caribbean. And in practically the next breath, he threatened to deploy U.S. armed forces to Chicago. And then shortly thereafter, there was a statement confirming the military operation by Secretary of State Marco Rubio, and the president posted on social media video of the strike in which he claimed that 11 people were killed, characterized them as terrorists or narco-terrorists, alleged they were members of Tren de Aragua. And then the administration didn't actually offer out much more information about that strike. A few days later, there was a formal notification to Congress under the War Powers Resolution, which we can get into, that notably did not specifically identify the entity targeted in the operation or the individuals themselves who were killed. And then again, earlier this week on Monday, we had another strike in the Caribbean, this time reportedly killing 3 people. Again, characterized by the president as narco-terrorists. And as with the first strike, both of these were reported by the administration to take place outside the territorial waters of any state, and what the administration refers to as international waters. And these strikes occur in the context of both a broader military deployment to the Caribbean, understood to be pushed by Secretary of State Marco Rubio. And this includes destroyers, thousands of Marines, sailors, nuclear-powered submarines, 10 F-35 fighters. And this is saber-rattling to put pressure on Venezuelan President Maduro in the hopes of Rubio to get him to step down or inspire others in his government to topple him. So that's going on at the same time as these strikes on vessels in the Caribbean. The other bit of relevant context is since President Trump took office again, the administration has been characterizing a range of foes as terrorists. This is true of Latin American criminal organizations, including Tren de Aragua. 8 of these entities for the first time were designated as foreign terrorist organizations in February. It was the first time that the State Department had ever designated criminal organizations as terrorists in this fashion. The administration has also referred to migrants generally as terrorists. And then again, this week, the administration has again been labeling domestic political opponents as terrorists, with the President of the United States himself saying that he was going to designate Antifa as a terrorist organization, which as a legal matter is not a thing under U.S. law, but nonetheless is significant politically.
Okay, so that's a lot. So let's go back. The putative justification for this attack is that these people are bringing drugs to the United States?
Yes, that is part of the justification. And the alleged involvement in drug trafficking, also in the minds of the administration, provides a hook for labeling these individuals as terrorists. So I think this framing is very important, that they are trying to repurpose the war on terror framing and apply it to criminal groups in Latin America, and in this case, possibly Trinidad and Tobago, though, as I mentioned earlier, we don't actually know for certain who these individuals were.
Have we been offered any evidence that these people actually are drug traffickers?
No, the administration has really not substantiated any of its factual claims.
Right.
It has not presented evidence as to what the cargo was aboard the vessels, not provide any evidence as to specifically who the people were or what entities they might have been affiliated with. So we have more questions than answers in regards to what happened. But the facts, even if they are as the administration presented them, would not justify the use of lethal force in these situations.
Right. So can you actually talk to us about what would be the normal thing? Let's assume that it is true. What would be the normal thing that would happen if there was, a vessel carrying drugs to the United States in the Caribbean Ocean?
Well, the United States has a well-worn playbook that is used for decades to interdict suspected drug smuggling vessels in the Caribbean, Pacific, and elsewhere. And this involves the U.S. Navy working with the U.S. Coast Guard to stop the vessel, board the vessel in a law enforcement paradigm. And usually it would be, the Coast Guard boarding team search the vessel. And if appropriate, the Coast Guard, again, acting in a law enforcement paradigm, would take into custody members of the crew, and they'd be processed through the U.S. criminal justice system. Okay, they'd be prosecuted in Article III courts. And again, this is all happening in the law enforcement paradigm, in which the use of lethal force is used as a last resort. Okay. And, shots may be fired to disable a vessel, into the motor engines to disable a vessel. But lethal force would not be used against the vessel or its crew in the first resort. And that's what happened here, that the president was reportedly presented with the option, this is according to Marco Rubio, presented with the option to conduct an interdiction and rejected it because the president wanted to blow up the vessel to send a message, in the words of Rubio. Okay. So they had an option to use the standard law enforcement approach, and they rejected it.
So I want to ask a couple of questions based on what you just said. You used the phrase law enforcement paradigm. And to us, where we think about that in terms of domestic law, that would imply standards of due process. When you're talking about applying that internationally, is there, and to what extent do suspected drug smugglers, to what extent are they entitled to due process, right? You've said it's not a violence first, it's a violence as a last resort, but are there other protocols or protections that attach when you're operating in that law enforcement paradigm?
Well, yes, when these people are, ordinarily when they process into the system, that they would be afforded all the standard protections of the U.S. criminal justice system. And the distinction I'm trying to draw here is between the law enforcement paradigm, in which due process would be afforded, and evidence would be presented to a jury. You'd have to establish guilt beyond reasonable doubt, all of that. I'm distinguishing that paradigm, okay, from an armed conflict paradigm, okay, in which lethal force may be used in the first instance.
And you have anticipated my second question, right? Which is that the justification coming out of the White House, coming out of President Trump and Secretary of State Rubio has been the president is commander-in-chief of the armed forces. His power is plenary, is unreviewable, is non-justiciable. If the president says, I'm using the army in this particular way, who is anybody to say, no, you can't? And I suspect that assertion is incorrect, but since I can ask you about it, can you talk about can you evaluate that statement for us?
You're correct. It is incorrect that the president's authority is reviewable and is not plenary. In the words of Supreme Court Justice Jackson, that's Robert Jackson, not the current Jackson. The president is commander-in-chief of the U.S. military, not commander-in-chief of the United States. So I think what's important to recognize here is, even though the administration is using the framing of counterterrorism, using the rhetoric of war, using the trappings and tools of war and counterterrorism, this is not actually war. This is not actually counterterrorism. Okay, it is deploying these labels to justify its actions, but those labels are simply inapt and inapplicable here.
Yeah, can you talk us through that? Because it's really hard, I think, for sometimes we're all lawyers. We understand that there is this kind of division between civilian law enforcement and military enforcement. But can you explain exactly why this is not a war, right? We're not in a war with drug cartels.
Okay, for these purposes, I'm going to be using the term armed conflict, which is the legal term of art here.
Mm-hmm.
Okay,
Mm-hmm.
for there to be an armed conflict between the United States and a non-state actor, you'd have to establish that certain criteria were fulfilled. One, that the non-state armed group was an organized armed group, that it had a structure and functions roughly analogous to those of a state military, a hierarchy, chain of command, the capability of conducting and coordinating military operations, internal discipline, the capacity, if not the willingness, to comply with the law of war. Okay,
Mm-hmm. Mm-hmm.
And then there has to be a sufficiently intense level of violence between that non-state entity and the state military. Okay, here, and if that was the case, then the law of war would apply, and the law of war imposes certain restrictions and prohibitions, but also permits the use of lethal force in the first instance against combatants, civilians directly participating in hostilities, and destruction and attacks upon military objectives. Okay, but in this situation, the administration has not even made any serious argument that there is an armed conflict. It's thrown around sort of war rhetoric, but it hasn't actually really made the case that there's an armed conflict. Okay, it hasn't put forward arguments, certainly hasn't put forward information to support such arguments if it were to make them. And even if it tried, it would probably be unable to do so convincingly. Assuming, for sake of argument, that it is Trinidad and Tobago that the administration has been targeting in the Caribbean, and again, they haven't actually made that totally clear. It's probably not the case that Trinidad and Tobago would meet the criteria for being an organized armed group, at least according to my colleagues at Crisis Group who are more expert on the region and Trinidad and Tobago than I am. And so, they're using the rhetoric of war and counterterrorism, but they don't actually have the legal framework that would be necessary to justify these premeditated killings.
So let me see if I can kind of summarize what you've just said to make sure that I understand it. And that is when we are talking about the United States using force against targets who are in international waters, right, against non-U.S. citizens outside of the country, you started with the proposition that there are constraints regardless of what path you use, right? That the commander-in-chief power is not plenary. And then it sounds like there are basically two options, right? If you have an organized armed group that is on a par with the state military, then the law of war would apply. And obviously we're going to talk about what that is and the criteria that exist when the law of war does apply. If you don't want to go the law of war route, then you proceed in the law enforcement paradigm route. But either way, there are checks and controls on how force is exercised. Do I have that right?
Yes, there are rules in either paradigm. And I should also say that there's threshold questions about resorting to force in the first instance, which I'm happy to unpack as well.
Oh, yeah. Go ahead. Explain that.
So, when I was advising on these issues at the State Department, and I advised on lethal counterterrorism strikes, you would have to ask yourself, as the threshold matter, what is the domestic legal authority for the president to use force at all? Okay. Mm-hmm. And then you'd have to look at, as an international law matter, would the use of force be lawful? As your listeners may be aware, Article 2.4 of the UN Charter prohibits the use or threat of the use of force by states in their international relations. And so you'd have to consider whether that prohibition was implicated. And if it was, whether there was an exception that would otherwise allow military action, such as self-defense or an authorization by the UN Security Council.
Okay. Thank you. We will be right back after this brief ad break, unless, of course, you are a subscriber over at patreon.com/lawandchaospod or on our Substack at lawandchaospod.com. And we will rejoin you after that break with more with Brian Finucane.
And we're back with Brian Finucane. Okay, Brian, here's my question, right? If I don't know anything about the law of war and I see a video that looks like something out of like a video game of us blowing up a boat that looks to me like a fishing boat. My question is, why isn't this murder under U.S. law?
That's my question as well.
Okay.
One I would put to the administration, one they have not adequately addressed. Okay. We have a term for the premeditated killing of people outside of armed conflict, and that term is murder. And there are relevant provisions of U.S. law that would apply here, even outside the United States, that prohibit and criminalize murder. These include Article 118 of the Uniform Code of Military Justice, to which U.S. service members are subject to. These include criminal statute under Title 18 that makes it a crime to commit murder on the high seas. Okay. And as I noted earlier, these strikes allegedly took place outside the territorial waters of any state. And for the purposes of this murder statute, that would make it the high seas. And it's also a federal crime to conspire to commit murder outside the United States. So those are all potentially relevant criminal law considerations, and ones that I certainly would have raised if I were advising on this operation, if I were still inside the U.S. government. And the Trump administration has not explained why these, criminal law prohibitions are not implicated by these strikes.
Yeah, I mean, as I understand it, Marco Rubio has said basically, well, interdicting them hasn't stopped drug smugglers, so we had to kill them to show everybody a lesson. And that does not actually sound like law to me.
No. I mean, in principle, there could be a affirmative self-defense to a murder charge, right? I was acting in self-defense of myself or others against some imminent threat. But based on the rhetoric of the administration, what they've actually said completely eviscerates the possibility of any such affirmative defense. The fact that Rubio told the media that the president was presented with the option to conduct an interdiction, okay, makes it very, very hard to argue that this measure was self-defense for the purposes of criminal law. And more fundamentally, drug trafficking itself doesn't pose the sort of threat that would entitle an individual to use lethal force for criminal law purposes. The New York Times has reported that the first vessel, at least, was turning back to Venezuela at the time it was struck. And so there's just really not the predicate there for establishing this sort of affirmative defense to claim that the U.S. was acting to protect the lives of American citizens, American service members, or anyone else from the sort of threat that would entitle this sort of use of force.
Right. I mean, The Intercept reports that there were survivors after the first strike and they killed them in the water. So that's clearly not, a defensive killing. That's something else. I think that's mostly much closer to what we would characterize as murder. I mean, has the administration offered any legal defense other than we're, beating their chests and saying, aren't we tough? Look at this, thing that we did.
It's mostly been legal Mad Libs thus far.
Yeah.
The War Powers report that was put out on the 4th of September is the most formal legal justification we have. And it's shockingly bare bones in terms of the law.
Right. So the War Powers report is what they have to tell to Congress, right? They have to come back post facto and say, okay, here's what we did and here's why. But what did it say?
Okay. It talked about the fact that the targets were assessed to be affiliated with a designated terrorist organization, without specifying what the organization was or the identities of the individuals struck. It used the language of self-defense. Self-defense is cited a few times in there, okay? And then it talks about the president using force under Article 2 of the Constitution as the commander-in-chief and chief executive. That part is not surprising. When the president uses force, he can do so under two bases. One is some congressional authorization or declaration of war. Obviously, nothing relevant here. The other is under claimed authority of Article 2. And we can get into that further. But what the War Powers notification did not do is sort of lay out any detailed justification for the killing of people in the first instance, the use of lethal force here.
So I want to ask a couple of questions about that, because previous presidents up through and including President Biden have cited the 2002 Iraq congressional authorization for the use of military force, which Democrats and Republicans alike have interpreted incredibly broadly and then have submitted War Powers Act reports to Congress and said, we believe that this 2002 AUMF authorized this particular strike. Here's what we did. And that's my understanding of how the president complies with the War Powers Resolution. Cites to an authority, says, here was the authorization and here were the permitted actions that we took pursuant to that authorization. And my understanding is that that's been pretty expansive, claim by past executives. So I guess my two questions are, number one, does this comply with that standard? How does that compare against the backdrop of presidents offering sort of expansive justifications for military use in the past?
So I think it's a good opportunity to take a step back and describe what it is the War Powers Resolution requires. Perfect. So this law was enacted by Congress after a protracted effort in the waning period of the Vietnam War. And it was a response to perceived oversteps by the executive, in particular the bombing of Cambodia by the Nixon administration. When Congress felt that it had not authorized the underlying military activity, and in many cases wasn't even aware of it. And so the War Powers Resolution, which was enacted over President Nixon's veto, it imposes certain reporting requirements and substantive constraints when the president uses military force without prior congressional authorization. And that last part is really key. It becomes really relevant when Congress has not otherwise enacted, a declaration of war or an authorization for the use of military force. And so here, the relevant provision of the War Powers Resolution is a requirement to report to Congress within 48 hours whenever U.S. armed forces have been introduced into hostilities or a situation of imminent hostilities. Okay. And because there is no relevant congressional authorization here, the administration submitted a report on the 4th of September with respect to the first strike. Okay, and that's what we've been describing here, what it is that the administration laid out in that report. So as far as the sort of the legal justification as a matter of, congressional war powers, constitutional war powers offered, the citation to Article 2 is what you would expect. Since there's no congressional authorization, only basis which the president could justify this, use of force at all would be with reference to, inherent power under Article 2 of the Constitution, as we saw here.
As commander-in-chief, the sort of vague powers delegated to the president by the Constitution.
And I'm happy to talk about whether that is an appropriate invocation of Article 2 and the appropriate vision of war powers that the framers of the Constitution might have had in mind. But that's not surprising that the president would cite that. But what is conspicuously absent here is any sort of separate justification for the use of lethal force in the first instance, right? That doesn't addressing the murder question that you raised a moment ago, Liz.
Right. And can you actually, since you've offered to do it, can you talk a little bit? Because we hear Trump say over and over again, I have an Article 2 and it's very powerful. And I'm not sure he knows where that article sits that is part of the U.S. Constitution. But explain to us why you don't, as president, have, plenary power to make war or to attack our enemies wherever you find them.
So I think there's a few really important constitutional points here. First and foremost, the framers of the Constitution gave the bulk of the war powers, including the power to declare war, to Congress, okay? Because they wanted to make going to war hard. Okay, because it was one of the most important decisions, momentous decisions the country could make. This expenditure of blood and treasure, and they did not want to leave it up to the whims of one man. And so they gave it to Congress to require collective decision making, public debate, and deliberation over this momentous decision. But at the same time, the framers recognized that there might be circumstances in which the president would have to act rapidly and unilaterally without prior congressional authorization. And though it's not in the text of the Constitution itself, there are contemporaneous notations that the framers understood that the president would at least have the authority to respond to or repel sudden attack upon the United States. Okay,
like an invasion.
Yeah. And you can imagine a scenario where Congress, members of Congress are days ride away on horseback from coming back to the Capitol. The president has to act immediately to repel an invasion, and he can do so until Congress can get back to the Capitol and decide what it wants to do about the situation.
Right.
That is obviously not the scenario we're facing here.
Right.
But over the past 250 years, and particularly since the end of the Second World War, the U.S. executive branch has developed a very permissive legal doctrine about when the president may use force unilaterally, that is without prior congressional authorization.
Mm-hmm.
And the current sort of test articulated by the Department of Justice's Office of Legal Counsel has two prongs. The first is whether the use of force would advance a sufficiently important national interest. That national interest test is not very constraining at all. Office of Legal Counsel has identified a whole number of different national interests that would justify use of force. And I expect, countering illegal narcotics trafficking is one they may have identified for this operation. And then the second component of that test, the second prong of that test, is whether the expected use of force would rise to war in the constitutional sense, such that it would require congressional authorization. And OLC has looked to the anticipated nature, scope, and duration of an operation, with the presence of U.S. ground troops being particularly relevant consideration, as is like the risk of escalation. And so, if you apply that framework, executive branch framework, to this operation, it's easy to see how the Department of Justice might justify it. Okay, it's just as a on the use of force question, setting aside for the time being the lethal action component. But I also want to note that this is the executive branch's framework. It's not been endorsed by Congress, not been endorsed by the courts, and it appears nowhere in the text of the U.S. Constitution.
Right. And who would, let's play this out. Would this be something that Congress would vindicate? Because, not this Congress, obviously, but a Congress that wasn't totally supine. Is this a right that Congress would vindicate by, trying to seize its power back or suing? Or, who could vindicate this theft of power, the power to declare war from Congress?
It would have to be Congress to reassert its constitutional prerogatives in this space. There have been efforts over the years, since the War Powers Resolution was enacted, to reform it, to buttress it. There have been responses in particular situations. The War Powers Resolution not only imposes these reporting requirements, and I should also note that some other key aspects of it. It also imposes a 60-day withdrawal requirement once U.S. armed forces are introduced in hostilities. Okay, and it also provides for expedited procedures by which members of Congress can introduce legislation that will be entitled to expedited procedures, entitled to a vote to require the removal of U.S. armed forces if they've been introduced without prior authorization. So you have both a 60-day deadline, which by my mind, the clock is currently ticking on operations in the Caribbean, but Congress also has a tool to force withdrawal even before then. Okay, and we've seen efforts in recent years to use that tool. We saw under the first Trump administration, a War Powers resolution under the War Powers Resolution to force withdrawal of U.S. Support for the Saudi operations in Yemen. Okay, we saw again in 2020 following the U.S. strike on General Qasem Soleimani in Baghdad, which almost kicked off the war with Iran. Resolution put forward by Senator Tim Kaine. They got bipartisan majorities in both houses of Congress, and had to be vetoed by Trump. And we saw again over the summer, and again led by Tim Kaine, resolution introduced to prohibit further U.S. hostilities with Iran after the U.S. attack on the nuclear facilities. And so we're seeing efforts right now in both houses of Congress to use the mechanisms provided for in the War Powers Resolution to move legislation that would prohibit further military operations in the Caribbean.
Okay, hang on one sec. I'm going to take another ad break, and then I do want to ask you about this kind of push-pull. And we're back with Brian Finucane. Brian, before we left, you were talking about a lot of the sort of maneuvering under Trump, the back and forth, the push-pull between Congress and the president over use of force. And I think that most people understand that in the modern era, there has been a lot of this kind of push-pull with presidents. We think about Vietnam, which was not a war. It was like a enforcement action or something. There has been a lot of this tension between the White House wanting to seize control of military force and the president make these unilateral decisions without Congress. Do you want to talk about some of that history and how that plays into what's happening here, and whether it's, is this kind of the fruits of the global war on terror?
Yeah, in some respects, I think some of the current dynamics we see in Congress since 2001, when the war authorization for the campaign against ISIS, Al-Qaeda, the Taliban, Al-Qaeda, the Taliban initially, and then the executive branch added ISIS. Since that authorization was enacted. That's the 2001 authorization for use of military force, or 2001 AUMF. And then again in 2002 when the authorization was enacted for the Iraq War. Okay, so that really sort of marks the beginning of our current era of war powers. And one of the lessons that members of Congress took away from those experiences, particularly the Iraq experiences, is that they don't want to have responsibility in these matters of war and peace. They want to avoid a vote one way or the other that could come back to bite them. Okay.
No, can you play that one out for us? Because I don't think most people kind of understand it that way, that Congress, like, look, we're watching, right, Trump seizing the power of the impoundment, right? He's seizing the budget and he's seizing tariffs. And in some sense, it looks like the Congress is suddenly abandoning the field. But I think what you're saying, that it isn't sudden, that Congress may not want responsibility for unpopular actions.
Yes, for things that could turn out badly. So that they're happy to cheer things on while they seem to be going well, but they don't want to own any downsides. And so some members of Congress are perfectly happy to avoid taking responsibility. And so that's why it's been a dynamic since things really turned south in the Iraq War. And you've seen this play out, during the Obama administration, for example, when the U.S. intervened in Libya. Even members of Congress who were supportive of that operation didn't want to actually vote for authorization. Mm-hmm. We saw that again, in Syria on a few occasions after the chemical weapons attack, the lethal sarin attack in 2013. There was talk of U.S. military intervention, and even hawks in Congress, for the most part, didn't want to actually vote for an authorization for the president to take action. They prefer he act unilaterally. Ultimately, President Obama elected not to and resolve the matter or address the matter diplomatically. And again, with the military campaign against ISIS. And I misspoke a moment ago to say that Congress had voted in 2001 to authorize military action against ISIS. That's not true. Of course, ISIS arose later as a result of the Iraq War. And the Obama administration launched military operations against ISIS unilaterally in 2014, did not have congressional authorization. But again, even members of Congress at the time who were supportive of that action didn't really want to vote on it. They didn't want to take responsibility if things went badly.
But that went under the 2001 AUMF. I mean, most of this stuff in the in the Middle East or Middle East writ large has been under the umbrella, at least the rhetorical umbrella of the 2001 AUMF for after when we invaded Iraq and after after 9/11.
Yeah, so there's the two different war authorizations that have been used in the last 20-something years are the 2001 AUMF, which provides the authority for military operations in the war on terror. So it does not actually specify the enemies, and it leaves substantial discretion to the president there. But it was understood to be an authorization to go after those who had perpetrated the 9/11 attacks and those who harbored them or otherwise aided them. And so that was obviously Al-Qaeda and the Taliban, as it turned out. But the language is non-specific, and that's in part I think, a large part due to the fact that it was enacted, within a week of the 9/11 attack. So it wasn't entirely clear who the perpetrators were at that point.
Okay, so clearly the 2001, neither of these AUMFs about the Middle East is going to cover what we are doing here. Is there something that could cover it? I mean, is there any putative justification that could make sense, or is this so clearly extra legal that the only question is what do we do about it?
So yes, neither of these war authorizations from 20-some years ago plausibly apply in these counter-drug operations in Latin America. And so the president would have to rely solely on Article 2. And in terms of pushing back, I think Congress is the appropriate institution to push back on two levels, both against the unauthorized use of military force, but also against the apparent premeditated killing of people, and apparently outside the law, as the administration has not presented a legal justification for these killings. And I think that's particularly important for Congress to push back against that claimed prerogative, because it amounts to the president asserting to have a license to kill. If the president is not bound by U.S. criminal law, not bound by the constraints of the law of war, it is not clear what is to stop him from deploying this supposed prerogative elsewhere.
And elsewhere, play that out for us, right? If he can get away with this, what constraints are there?
Well, as I said at the outset, the administration has labeled and framed not just Latin American criminal entities as terrorists, but also immigrants to the United States more generally, as well as domestic political opponents. And so if the president is asserting a prerogative to kill anyone that labels a terrorist outside of the law, it's all too easy to see how that might be deployed at home.
Right, and we are seeing that, right? That's this theory that we're being invaded by Venezuela, trend to Aragua. And actually, can I back you up to something that you said earlier that was really interesting, right? That you said this is kind of a part of the U.S.'s pressure to effect regime change in Venezuela. Right. And I think that is kind of the sub rosa thing that's happening. It's like Trump declares that we have to, tariff China and Canada over, fentanyl. But what he really wants is to like change Canada's tariff regime with respect to U.S. dairy. Right. That if you can solve a drug problem by changing, your tax law, it was never really a drug problem to begin with. And I think I really would like you to kind of play out like we saw in the first Trump administration that they did, in fact, try. I think it was Bolton, tried to overthrow the Venezuelan government and install someone else that we liked better. And that I think, are you saying that this isn't really about drugs? It's really about our wanting to get Maduro out of there?
So there are a lot of moving pieces here, actually, and different interests on the part of different factions within the administration. So you have Marco Rubio, who wants regime change in Venezuela. Okay. And so he's the one pushing the broader military deployment to the Caribbean. Okay. You have folks like Stephen Miller who prioritize immigration and deporting Venezuelans. Okay. There's still deportation flights happening from the United States to Venezuela. You have others in the administration who are really keen to play up the narcos as terrorist theme for a variety of reasons. And these might include, I think, Miller and the president himself to some degree. I think that's helpful for domestic political purposes. It ties into the characterization of migrants generally as terrorists. And we saw this with when they invoked the Alien Enemies Act against Trinidad and Aragua in the spring and sent 200 some men off to terrible prison in El Salvador. And there are some tensions between these various interests, including Trump's, I think, reluctance to get involved in Operation Venezuela Freedom. So, the U.S. is engaged in performative action down there. I think performative at many levels, and that trying to intimidate Maduro, put pressure on Maduro. Performative in the sense that the president of the United States is posting these videos on social media. I think the president likes the optics of that. He likes dramatic military action. But the United States is not actually taking direct action against Venezuela itself, the territory of Venezuela. There's likely Venezuelans aboard these boats that were killed, but the U.S. has not conducted strikes on the territory of Venezuela itself. And I think it's likely because the administration doesn't want to jeopardize current cooperation on these deportation flights. And so these things, the strikes in the boats may represent sort of a compromise sweet spot that accommodates the interests of these various factions. Right. I will also say they also likely serve the purpose of putting pressure on other governments in the region to step up cooperation with the U.S. on, security and counter narcotics.
Yeah, Brian, you mentioned Operation Venezuelan Freedom in that answer. Can you unpack that? What that is? Why the administration doesn't want to be a part of it? Just unpack that for us.
I'm being a bit glib. It's reference to Operation Iraqi Freedom.
Yeah.
So I don't think that the president of the United States is not a dove. And he likes performative military action, likes dramatic military action, whether it's strikes on actual terrorists in the Middle East or strikes on boats in the Caribbean. He likes posting these videos on social media. I don't think he wants to mount, a massive invasion and regime change operation in Venezuela.
Right. Even the first go.
I thought that might be where you were going, but I wanted to make sure.
And the U.S. is not. U.S. has a massive military buildup there in the Caribbean. But it is nowhere near what you would need if you wanted to actually mount an invasion of Venezuela. Okay.
Right. Wasn't there sort of this goofy, like we sent some guys in boats, 200 of them or something the last time?
In Trump 1, 1.0, there was a, even more farcical version of the Bay of Pigs.
Right.
I think it's not entirely clear how involved the U.S. government was in that, but yes, there was something fairly absurd that took place. I don't think get the sense that this president is interested in launching a massive invasion of Venezuela. Limited airstrikes can't be ruled out, but I think again because of the implications that would have for cooperation on migration. I think that's less likely. And so what we're left with is this saber rattling, this hope that somehow this will intimidate Maduro into stepping down or embolden others in his government to topple him. I think that's very unlikely to happen, but I think that's the hope on the part of the Secretary of State.
Okay, so we've gotten kind of into the weeds about the way this is supposed to work, right? The built-in checks and balances, the push and pull between Congress asserting its power to declare and oversee wars, the congressional desire maybe to shift the burden of unpopular actions onto the president, and the president's Article 2 assertions that have been ever expanding in the 20th and 21st century. But now let's kind of move to the law of war itself, right? Because I think the question is, what are the international frameworks? What is the law of war? How does it apply? How's the administration violating it? Even assuming that there is some sort of framework for using military force here. Like, assume all those arguments to be true. I take your position to be that even if there was some justification, even if Congress back formulates something, that this still violates the law of war, and unpack that for us.
Sure. So we talk about the law of war. Is also referred to as international humanitarian law, or the law of armed conflict, LOAC. It is comprised of various treaties that the United States is a party to, most famously the Geneva Conventions in 1949, but also customary international law that is binding on the U.S. by virtue of state practice and opinio juris. And that's actually going to be the components that are going to be more relevant for things like targeting. Many of the provisions of the First Additional Protocol to the Geneva Conventions are regarded to be customary international law, even though the United States is not a party to that treaty. Okay, and those regulate, in addition to the some other elements of customary international law. Those are really going to be some of the relevant rules regarding targeting, who may be targeted, what may be targeted. And so for the purposes of the law of war, there are distinctions drawn between civilians who may not be made the object of attack, and combatants who can be subject to lethal force, who can be attacked. Civilians who directly participate in hostilities can also be attacked, and that's a term of art. And an example might be a civilian who picks up a rifle and shoots at enemy forces, or a civilian who's going to set off a roadside bomb. Okay, they can be attacked for the duration of their participation in hostilities.
Can I ask you a question?
Yeah.
Because you've talked about all of these kind of classifications of targets as civilian or non-civilian. And one of the things that we've seen the Trump administration do in all of this litigation, no matter what every piece of it, is that the Trump will define something. We'll define something down to, we'll define migrants as terrorists, or make some kind of justification where he says this is an emergency and I have defined it as such. And so what I wanted to ask is, if there were legal action, would Trump's classification of these possibly fishermen, as militants, legitimate conflicts, would that be a justiciable legal question, or would that be a political question or a foreign policy question outside review of courts?
So there's a few things going on here. One, they haven't even seriously made that argument. Okay. If they were to, it's difficult to see how you would actually move any sort of litigation forward. The courts have been very reluctant to sort of get involved on issues relating to lethal targeting and the actual war on terror. Reluctant in the sense of weighing in on the merits of it. Where you could most likely to see substantive judicial action resulting in a ruling on the merits would be if the United States were to take detainees and hold them. Okay, you could imagine a potential habeas suit filed on behalf of the detainee, and we saw a number of such actions in the course of the real war on terror that resulted in a body of case laws for sketching out some of the bounds of the president's war powers in that conflict. Okay, and when I first got wind of the proposal to start attacking boats in the Caribbean, that was one of the first things that occurred to me. So under what authority are you going to hold any detainees? And for the purpose of the war on terror, the authority was the 2001 AUMF. The courts never reached the question of whether the president had inherent authority under Article 2 of the Constitution to hold people as law of war detainees. And so it's sort of an unresolved question, the scope of the president's authority to hold people solely under Article 2 as law of war detainees. Of course, this administration has avoided that problem by simply killing everybody aboard those
Right.
vessels, not taking any prisoners thus far.
Yeah, that looks like a sort of a perverse moral incentive, right? Not to take them.
Very, very much so, and it's one others have commented upon in the course of the actual war on terror, because the complications involved with taking detainees, including litigation. But that is like the most obvious path that I could see to sort of having courts meaningfully weigh in on these issues. But again, the administration has not even seriously argued that there is an armed conflict governed by the law of war. It has not advanced any argument that the people aboard these vessels were lawful targets because they were somehow combatants or directly participating in hostilities. It hasn't advanced any sort of argument, much less substantiated, that the vessels or their cargoes were somehow military objectives for law of war purposes.
Mm-hmm.
And so, again, we really don't have anything of way of a real substantive justification by the administration for the premeditated killing of the people aboard these vessels.
Okay, Brian, hold that thought. We will be back with more after this brief ad break. Okay, so Brian, you have described the law of war, international humanitarian obligations, as being implemented through treaties to which the United States has been a signatory, that Congress has ratified and then adopted procedures. And I want to ask a little bit of a technical question of how that works. So maybe from my perspective, as somebody who's decidedly not an expert in this area, I think about the Geneva Convention, right? That says we're not going to torture, we're not going to target innocent civilians. And you just described the perverse incentive for the government to kill rather than detain, so that there are no class of detainees to bring a Boumediene v. Bush type of lawsuit. I guess I'm wondering if the United States, if a family of civilians, would they proceed, right? Suppose they allege that the United States has violated the Geneva Convention, right? And the survivors say, the United States engaged in unauthorized targeting of, my brother, my parent, my child, whatever. Would that be a civil lawsuit? Like what are the nuts and bolts about how non-U.S. citizens go to hold the United States accountable for its treaty obligations?
Well, I have some bad news on this front, in which there is no.
Oh, good.
There are no really obvious good mechanisms for that to happen as a judicial matter in the short term. On the international plane, if the United States continues with the strikes in the Caribbean, it is in principle possible that at some point these will amount to crime against humanity, say a widespread systematic attack on a civilian population. I don't think we've checked that box yet, but that's an international crime, okay, including for the purposes of the ICC, which has jurisdiction in the situation in Venezuela. But it's also a crime under the laws of many other countries, and some of these countries have universal jurisdiction, okay? So that's, in principle, one potential mechanism by which there could be, criminal prosecutions abroad in relationship.
So let me just cut it, make sure I understand that. You are saying that Venezuela or some other nation might arrest a United States official abroad and then try them overseas for war crimes. Is that what you mean by universal jurisdiction?
Yeah, that's what I mean by universal jurisdiction. And you wouldn't have to implicate, universal jurisdiction for Venezuela itself to take, to prosecute the killing of its, citizens. And no doubt there are, murder statutes in Venezuela. But I just think it's very unlikely that any U.S. personnel are going to be traveling to Venezuela in the foreseeable future.
Right.
But, in principle, this could be a consideration in some European countries that have laws on crimes against humanity and provide for universal jurisdiction. Again, I don't think we've reached the threshold where you can characterize these strikes in the Caribbean as a crime against humanity. But if the U.S. keeps it up, as the Trump administration has vowed to, it may become more of a real consideration.
And just one last question on that to make sure that I'm following what you're saying. You were suggesting that in the future, if, say, Marco Rubio is traveling through France, that France might seize and extradite him to Venezuela to be tried under Venezuelan law.
So that's also a possibility, as is the potential of being prosecuted in some European country directly. France and Switzerland, for example, have conducted recent prosecutions pursuant to universal jurisdiction of people for atrocity crimes committed elsewhere. I don't think we're at the crimes against humanity stage yet. With these two strikes, it certainly seems to implicate U.S. domestic criminal law, including murder prohibitions under the UCMJ and Title 18. But in terms of international prosecutions, I think we've got a way to go before we're going to reach the stage of being an international crime that most other states could potentially prosecute. And I think what we're left with for the time being is that courts, whether those are in the United States, on the international plane, or foreign courts, are not going to be the mechanism for reining in action by the Trump administration or preventing further strikes in the Caribbean. The institution that can really push back is going to be Congress. Okay, and there are a couple of different ways that Congress do this: through war powers legislation, which we now have both in the House and the Senate. It's unlikely any such legislation is going to become law, including because it's very hard to overcome a presidential veto. Okay, and any legislation, if it passed, would most likely be vetoed by the president. But I think it's very important nonetheless because it sends an important political signal. Okay, raises salience with the American public. Okay, and particularly if there are Republicans who sign on to this legislation that's bipartisan, I think it could send an important signal to the White House itself that these actions are opposed by some substantial number of lawmakers. So that's one mechanism. There are other mechanisms that Congress has at its disposal to put pressure on the administration, raising the salience of these operations through oversight, including shadow oversight, conducting shadow hearings, bringing in outside witnesses to discuss this, bringing in the families of victims if they can be identified and willing to come to the United States. And there's always the ultimate war power, which is the power of the purse. This is how ultimately Congress forced the end of U.S. participation in military operations in Vietnam, which was cutting off funding for the operations. Of course, you're going to need to get majorities to support that, but these are potential avenues in principle that Congress could avail itself to push back against these actions by the White House.
Yeah, so there's been reporting that there is something along the lines of what you've been envisioning from Senator Adam Schiff of California, and that there is a different legislation in the House to kind of retcon a justification for this war on drugs and in sort of equating drugs with terror. Can you talk about the second? What would that look like, and would it be legal? Could Congress kind of authorize war against a sort of nebulous drugs enemy?
Well, the model, unfortunately, for this draft war authorization, the New York Times and Washington Post report on this morning, the model is the 2001 AUMF, the 2001 authorization for the use of military force that provide the statutory basis for the war on terror. And so this draft legislation would repurpose the war on terror authorization for a war on narco-terrorists, which is not actually a legal thing, but it is trying to make it one. And it is incredibly sweeping, would confer vast war powers upon the president to use military force anywhere in the world, including the United States, potentially against U.S. citizens.
Wow.
And crucially, it would provide authority for detention.
Detention of whom?
Detention of narco-terrorists.
And whatever that word means, right? That's whatever Trump means. And Trump has said that he wants to nuke cartels or nuke drug manufacturing facilities in Mexico. So an authorization. It is, as we've seen, right? The 2001 AUMF has authorized operations all over the world in this global war on terror, and I think an authorization against drug manufacturers or cartels could be even more sweeping and dangerous.
Yeah, and there are the obvious distinctions between Al-Qaeda, the Taliban, and the other jihadi groups the U.S. fought after 9/11, First and foremost, they were organized armed groups. Okay, the U.S. could actually be in an armed conflict with them. It's somewhat nonsensical to say that the U.S. is in an armed conflict with, Trinidad, Aragua, or some of these other, criminal entities in Latin America. But also, as I mentioned earlier, one of the big reasons that the 2001 AUMF didn't specify explicitly the enemies against whom force could be used is that it wasn't entirely clear in the immediate aftermath of 9/11 who all the responsible parties were, who all the perpetrators were. And so Congress delegated the authority to the president to make those determinations. Okay. That is not the scenario we are faced with today. Okay.
Oh, that's a really good point.
And so in this draft legislation would confer, expansive authority on the president to decide who the United States is at war with and where the United States is going to go to war. Okay. Those are powers that the Congress must reserve. Okay? Congress cannot be delegating these powers to one man. Again, to get back to constitutional design, there is a reason that the U.S. Constitution gives the power to declare war to Congress rather than leaves it to the whims of one man, which is what this draft legislation would do.
Let's try and look at this kind of from a 10,000-foot view. I mean, it looks to me like this is really corrosive for, our society and for the rule of law to have a president who is doing this in an extra legal fashion. So I guess I want to ask you what the cost is, not just to these fishermen, not just to our international relationships with Venezuela, but to our society. And then I want to ask you, what do we do if we get to the end of this in 2029? What do we have to do to put it back together?
Well, there are a number of serious risks beyond the tragic killing of these people. One is normalizing internationally these sorts of premeditated killings, the sorts of killings that the U.S. government, including Secretary of State Rubio, used to denounce when they were carried out by people like the former president of Philippines, Duterte. Okay, but the other is that the president is asserting a license to kill people outside of the law here, and that is extraordinarily dangerous. And it's dangerous that it could be deployed elsewhere in the region, could be deployed at home. But the president is asserting incredible powers to act outside the law here, and Congress needs to resist that. It needs to push back against that. The American people need to realize the stakes and push their elected members of Congress to push back against the president on this.
Right, and I think in the Nixon era, Nixon kind of instigating like IRS audits of his enemies was a giant political scandal. And we've slipped so far that the president killing people has barely caused a ripple, asserting a license to kill, as you've said. And maybe that's because we've become so desensitized to it after 20 plus years of the global war on terror. But perhaps this is a result of this kind of massive delegation of power from Congress. And especially we've seen all of these emergency authorizations, not just for the use of military force, but, for tariffs and other, impoundment type activity that has caused this. Trump has been able to push all of these buttons that say emergency and assert power. And do you think if we got to the other side, do you think that kind of reining that in congressionally is the solution, or what is the way? Like, if we have to put this society back together, if we have to rebuild civil society, do you think it is the revocation of all of these emergency authorizations, or what would you do? Right, you've been in the State Department. What would you say? What guardrails would you put back in place?
It's a great question. In the last several years, there have been repeated legislative efforts at structural reform of executive power, including war powers and emergency powers. Okay, unfortunately, they didn't get much traction. They were bipartisan. They had Republican and Democratic co-sponsors. Didn't get much traction, and the Biden administration showed very little interest in them. Okay, it was a grave mistake. And so, looking down the road at reform, this sort of legislative reform is critical. Okay, to try to erect better guardrails with respect to the use of the war power and executive power more broadly. What we are living through right now is an Article 1 crisis, where Congress is all too happy to sit on its hands and abdicate its responsibilities. The Constitution gives Congress the power to regulate foreign commerce, gives Congress the power to declare war. Okay, well, these are just some of the authorities that this president has usurped, and to very little resistance from majorities in either house of Congress, and too often, very little resistance from the minorities in either house of of Congress. And so that's what I mean when I'm talking about the Article 1 crisis. This president is attempting to rule by decree, despite the fact that he controls legislative majorities and he could potentially get legislation through. But instead, he prefers to act unilaterally, often through executive orders or through taking military action without prior congressional authorization, as we've seen here in the Caribbean.
Yeah, I think that's so helpful to think about it, right? It's not just that Trump is seizing the power; it is that Congress is giving it to him. So yeah, I couldn't put it better than ending on this is an Article 1 crisis as well as an Article 2 crisis. So perfect ending. Thank you so much, Brian Finucane, and we hope to have you back under better circumstances.
It's been a real pleasure. Thank you so much.
Thank you.
Thank you.
Okay, Liz. Well, that was a fantastic interview with Brian Finucane. I really think that crystallizes sort of where we're going right now. We're obviously going to continue to talk about how we're fighting back in the courts. Some things cannot be fought in the courts. Some things require Congress to step up to the plate. And the way to make Congress step up to the plate is for we, the people, to show that at the ballot box. And I know we got gerrymandering. I know it's bad, but we have to be making this case publicly. We have to make our elected officials want to stand up against corruption, against naked violations of law. And that is going to do it for us for today. We will be back again later this week with new written content on Thursday and a new episode of the show on Friday. As always, if you can subscribe, that would be fantastic. If you can't, if you can head over to wherever you get your podcast from and leave us a 5-star review and hopefully a nice glowing recommendation. That really helps the algorithm, helps us reach a wider audience and share out the show with people that we think might like to hear what we've got going on. And as always, thank you so much for your support. Thanks for backing the show, and we will see you later on in the week.
Law and Chaos Podcast is a production of Raise Up to Media, LLC, is intended solely as entertainment, does not constitute legal advice, and does not form an attorney-client relationship. This show is researched and written by Liz Dye and produced by Bryce Blankenagel. Law and Chaos Pod, copyright Raise Up to Media, LLC, all rights reserved.